Wonderful. Well, thank everybody. Thank you all for joining. So my name is Josh Anderson. I'm Senior Vice President of Health and Welfare Benefits at Gallagher. And we thank you for your time today. So both Gallagher Benefits and Atlanta and Hall Benefits Law wanted to take some time today to go through your benefits and HR questions and really use this time to have a live question and answer forum for you all to answer any questions you might have in not only this COVID-19 world, but the return to work planning that most of the employers we are working with are going through as we speak. So we've transitioned from the unprecedented times into the new normal. So what is the new normal when it comes to work? So Gallagher Benefits has been doing what we call a pulse survey with a number of different employers. And as of 2 days ago, what we found, the top 3 factors most critically affected or will affect the timing of our employers, 64% of employers are concerned about health department guidance. 59% are waiting for governmental mandates, and 37% of employees comfort with return to work. So there's a lot of moving factors when we talk about what will impact people's return to work. We certainly know we work with some manufacturing clients that will be on this phone call, that the manufacturing environment that are actively at work. But what about other groups? Maybe the business functions of those different groups. When will people return to work? So 38% of partial workforce have already returned to work from the surveyed of almost 750 employers, while 13% have a full workforce return. You could see we have June through August in the third and fourth quarter. So there's a lot of moving parts when it comes to this return to work sort of dynamic. The last thing that I'll mention as we get into the overarching theme here is 39% of employers are undetermined when their entire workforce is going to return to work. So we certainly have a lot of moving factors, and we want to talk through some of the things that could impact these return to work scenarios through this webinar. Okay, so we really want this to be a forum for everybody that's dialed in here to be able to ask questions. Let me start by saying your questions are anonymous. So you'll be submitted, they'll be submitted through the question box on the bottom left side. You can type your questions and click send, and only the organizers will be able to see it. So after we go through a couple of slides and basic presentations, we'll get into the question asking portion. So the more questions you can ask, I think the better this will be. Both Hall Benefits Law and Gallagher will be available to answer questions, so please go ahead and start getting those organized, and we will go through questions as they come up. Okay, quickly for today's speakers. So I'll go through intros for everybody speaking today. I've introduced myself as Josh Anderson. Kevi Micus supports the human resources and compensation consulting needs of Gallagher clients. She's a trusted advisor to clients in the areas of aligning HR strategy and supporting initiatives, programs, and practices to organizational goals and culture. David Hall is the former firm manager and current chief marketing officer for Hall Benefits Law. He's a director on the board of the Southeast Benefit Education Network, and he is the ASPPA liaison for the ASPPA Benefits Council of Atlanta. Eric Schillinger concentrates his practice in the areas of qualified health and welfare and non-qualified employee benefit plans. He has extensive experience in helping employers comply with the various federal and state laws applicable to those plans. Keely Collins is an employment attorney representing businesses and agencies of all sizes. As counselor and advocate, the success of her clients is Keely's main objective. Accuracy, strategy, responsiveness, enthusiasm, and loyalty are the heart of Keely's value to the business she serves. And as a business owner representing businesses, Ann Tyler Hall understands firsthand the importance of strategically designed, legally compliant benefit plans aimed at attracting, motivating, and retaining top talents. So we're excited to present this group of panelists. We look forward to answering your questions. And as we move forward, we will start off with Kevi from the Gallagher Human Resource Practice. Kevi?
Kevi, I don't have your audio. Good morning, everyone. Is that better?
Much better.
Excellent.
Thank you.
Good, good. Good morning. Thanks for the opportunity to join you this morning. I'm really going to frame up this morning the conversation around you as HR leaders out in the audience. Now is our time to really come in and add our greatest value to the organization and really dedicate our expertise and thought leadership to ensure that our organizations are returning to work and bringing employees back safely, as well as ensuring compliance. And we do have, Keely's going to speak with you about some new and different areas of compliance that have really kind of flipped our area of focus and what we knew before on its head, if you will. And then the other element that is important for us to ensure that we've got our finger on the pulse of is just really leaning into our cultures right now and communicating with clarity and with our culture first and foremost. So some of the things that I want to spotlight that I think are coming up for me in where we're hearing some needs or issues or questions from our clients. One, as I mentioned, HR is now typically part of this broader task force that we're seeing where it's senior leadership and HR is at the forefront of that, along with IT and risk and facility managers, to ensure that we are looking at every aspect of bringing people back to work safely. And so understanding, obviously, not only our local and governmental guidelines, still keeping our finger on the pulse of CDC regulations, but we're also seeing, as it relates to how our employees feel about coming back to work, many of our employers are doing surveys and getting direct feedback on what percentage of our population is comfortable in coming back to work and how can we manage that. And do we want to still continue? Is remote work working for us? Has everybody continued to be successful in that environment? And do we really want to rush back into the office? So then continuing to have the supportive technologies and policies and effective leadership to support that remote work. And as it relates to that, leaders are now having to really use and flex different muscles, I think, in managing remote workers. And so it's important for HR to revisit some of the skill sets that maybe our leaders have and help to upskill those folks. So really looking at helping them with communication and clarity, really during this time when you have a remote workforce, over communication is paramount. And then running effective meetings and not just relying on people to always be engaged during those meetings. Okay, we know that they're not. So having more structured frameworks for leaders to run effective meetings, consistently doing check-ins with people, because it's not just about still getting the work done, but ensuring that our employees are okay, and how are they adjusting, how are they doing. And as it relates to that, we're seeing a huge uptick really in this focus around emotional well-being and resiliency, because we are under and we're seeing record levels of stress, anxiety, and burnout. And so even pre-COVID, we were already at high numbers as far as employees struggling with one form or another of mental well-being, if you will. So this is going to continue to be a huge focus. And in fact, one of our recent pulse surveys, as Josh pointed out, has indicated that being the highest area that employers are going to focus on and revisit as it relates to their benefit strategies and offerings going forward. So whether that be revisiting your EAP, also ensuring that you have, again, other things that don't necessarily cost money that can help your employees. There are a multitude of apps that you can, create in an overarching, kind of a resource toolkit for your employees. Just to give you an example, studies show that a mindset of gratefulness and development, or kind of always learning mindset, has a tremendous impact in our mental well-being. I use a free app. It's called Gratitude. And every night before I go to bed, I enter in an entry. And so it just helps me to reframe. If I've had a really stressful day, and I can see myself starting to, kind of dive into my personal life, my entry may be as simple as, I'm grateful for the fact that a dog didn't bark, or my kids didn't come in while I was doing a webinar today, right? So, just keep it simple and keep it supportive in all the areas of well-being, because we know the whole person comes to work, and that's not just their physical well-being, it's their financial well-being, it's their career well-being, and as I mentioned, their emotional well-being. And so all of those categories, we're working very, very closely with our clients to really revisit the employee experience in all of those areas. Interestingly, as it relates to career well-being, and so for those of us as leaders or HR folks, that's really inclusive of providing and ensuring role clarity. Are we equipping people with exposure to new and different things to expand their skills? And so we know we've morphed over time from establishing career ladders, because growth and enhancement in our development isn't always upward mobility. So looking at ways to, again, really ensure that our employees are feeling well within their career. And Gallup indicates when we are doing that, when employees feel well in their career, they are 2 times more likely to be well in all those other categories of well-being. So this is a great opportunity for us to revisit those areas of well-being, as well as performance management and rewards. So are we expecting different things from people now in this environment? And how do we align our rewards to those either new behaviors or new performance expectations? And then lastly, as I mentioned before, just to kind of end on it again, just the importance of leading with compassion, clarity, and culture during this time. So I know the rest of our conversation, you're going to get insights around some of the compliance pieces. And so I will turn it back over to David to keep us rolling along with the next speaker.
Thank you, Kevy. That's great. And I think all of us can relate to that, especially as members of businesses that have employees, and dealing with HR and folks' well-being is critical. And so we appreciate your perspective and look forward to more of that as the Q&A continues. Next up, we've got Keely, and Keely is Compliance Counsel here at Hall Benefits Law. Keely, take us away. Keely, you are muted. There you are.
Good morning. I'm absolutely thrilled to be here with you today. Employers who ordinarily have the task of driving forward their organizational goals and having to manage employees at the same time now are faced with a heightened level of legal risk, and as Kevy mentioned, in some ways, an upending of the legal risk that you already thought that maybe you had under control in speaking with your employment counsel. So I know your time is precious. Why be concerned about listening to an employment attorney give their perspective on what's going on right now with COVID-19? Kevy is very competent HR leader. She just about covered it all. But your employment attorney really is your risk management partner and risk management strategist. Employment law is not so much about right and wrong as much as it is about a well-organized business strategy. So I've been representing employers now for over 10 years, litigating and also in counseling, and I can tell you with 100% sincerity, in over 10 years of time, I have never seen a single individual who intentionally discriminated against employees or intentionally broken a law or intentionally retaliated in some way against employees. However, so many of these cases settle. Why is that? Well, really what it comes down to at times is weakness in demonstrating compliance. So it is key to have employment counsel at the table, obviously in addition to somebody talented like Kevy in HR, to help you to understand the framework of the risk management issues that you're dealing with when it comes to employees. And sometimes it's really just all about your documentation and making sure that you're able to demonstrate your great work, because you're all doing great work out there in managing your employees. It's just a matter of whether or not you would be able to demonstrate that if faced with a claim from any of these agencies or courts. So I have a top 10 risk management tips for you as you continue to encounter what is essentially an upending of these risk areas that we've been talking about for years and years. So first of all, OSHA has released a pretty thorough question and answer document for employers to follow to comply with OSHA's safety guidelines. And really what it comes down to, employers, is having an individualized plan. And one thing about employment law I can tell you has not changed is the importance of consistency to the degree that you can keep it. So having a well-organized plan that applies across the board to all classifications of employees that's consistent with OSHA's guiding principles will be key in helping you manage legal risk when it comes to maybe an audit or a claim with OSHA. Secondly, identifying personnel cost savings that do not result in heightened risk. That many employers, unfortunately, have had to cut staff. I mean, regardless of what anyone may think about employers doing that, I know you don't want to. I work with many of you. I know you don't want to have to lay off staff. But there are some ways and strategies that you can lay off staff that do not trigger other laws such as WARN and notification laws that may cause reputational and legal harm to the employer. Thirdly, adopting a telework policy. So the employees are able to telework to varying degrees. You're going to have your self-starters who actually perform better working from home. You're also going to have your employees who perform perhaps at a lesser level working from home because they don't have that skill set. So a telework policy can provide general guidelines for all employees when you're essentially shifting your entire workforce model from an in-person to a telework strategy. And of course, just to define terms, telework refers to working from home. Fourth, avoid liability for hidden areas of risk. I can tell you, just working with an employer recently, they asked me to look at a policy that was going to be put in place for telework. And the policy specifically said that employees with high risk are required to work from home, including older employees. Well, of course, the employer develops this policy with the best of intentions, and then the EEOC, Equal Employment Opportunity Commission, just recently comes out with guidance that says that older employees may not be, I can see Kevy kind of shaking her head, older employees cannot be just required to stay home, even with the best of intentions. And then finally, streamlining your accommodations process. This is an evergreen area of employment law. As employment counsel, we're always trying to strategize with you when you're trying to grow your business as to the best way to streamline the accommodations process. Well, now more than ever, it's crucial that the accommodations process be streamlined and simple for you to manage risk as best as you can under the Americans with Disabilities Act. Number 6, approaching temperature screenings with careful planning. In some states, temperature screening is required under some circumstances, but in any case, employers must be very careful about not interfering with employees' right to confidentiality under certain circumstances. And I think my 5 minutes is running up. It's hard for lawyers to keep a talk within 5 minutes. I could probably go on all day with my top 10 tips. But just finally, employers, reviewing and revising employee leave policies is going to be very helpful to you at this time, because this is one of those areas of legal risk that has been upended. Prior to the pandemic outbreak, employers, you were very concerned about making sure that employees did not abuse the sick leave policy. Of course, that is still true. We don't want sick leave policy abuse. However, at this time, most importantly, we want to help you manage your legal risk in other areas that may come into play if you have sick employees, particularly employees exhibiting some of the symptoms of the pandemic coming into work. So I look forward to your questions. I absolutely love answering questions that you have. I look forward to any questions you may have at the Q&A.
Awesome. Thank you, Keely. Just as an aside, we did receive a question asking about getting a copy of these slides. I know there's some really great information in here. Take a look at your handouts section. You can download the top 10s that we're going through. You can download a return to work guide. There are some combined COVID-19 resources from our firm, and there's an article by Kevy. So please take a look at those. You can download them directly from the handouts section in your portal. Moving on, we have Eric Schillinger, who is Senior Compliance Counsel here at Hall Benefits Law. He's going to talk a little bit about legal risk management in the health and welfare space. Eric, the floor is yours.
Thank you, David. And I'll do this really quickly because I want to save time for the Q&A, but I just wanted to give a quick kind of overview of what the compliance landscape is for employer-sponsored health and welfare benefits. So we're primarily talking about federal law here. There are cases where state law can apply to employee benefits plans, but in most cases, they're preempted by a federal law called the Employee Retirement Income Security Act of 1974, or ERISA. So in that regard, we're generally talking about ERISA rather than a state law. Now, there are, at least in the health and welfare context, multiple laws that apply. The two biggest are probably ERISA and then the Internal Revenue Code. Some examples of other laws that apply: the Affordable Care Act, HIPAA, which relates to, among other things, the security of protected health information. COBRA relates to the continuation of health insurance coverage upon certain events, such as a termination of employment. The other key aspect is the enforcement agencies, so who you're dealing with when you run into a compliance issue. The Department of Labor is enforcing ERISA. Department of Treasury and the IRS enforce the federal tax code. Then you also have Health and Human Services, parts of HIPAA. And then in some cases, you have multiple agencies enforcing multiple parts of a law. So for example, the Affordable Care Act has provisions that are enforced by the DOL, Treasury, and HHS. And in terms of non-compliance, it can take several forms. It depends on what law is being violated. So ERISA, potentially lawsuits from participants, DOL audits, civil monetary penalties, Internal Revenue Code, loss of favorable tax treatment. For example, a lot of benefits can be provided on a tax-favored basis. If rules aren't followed, that treatment can be lost. Excise taxes, penalties and interest, and of course, IRS audits. And then on the HIPAA side, penalties related to non-compliance with HIPAA, for example, where there is a breach of protected health information, there can be some pretty hefty penalties. So in terms of top 10 tips for liability risk management in the health and welfare context, and this is in our handout as well, as David mentioned, and actually there's more detail on each of these, so I'll go through these very quickly so that we can save time for the Q&A. So the first one I have listed relates to legislation that was passed recently, the Families First Coronavirus Response Act, included a requirement for plans, including group health plans, to cover diagnostic testing for COVID-19, as well as certain items and services furnished in connection with the testing. So this is mandatory. Plans are already subject to this requirement and applies through the period of the national emergency related to COVID-19. Depending on how your plan is set up, ERISA plans must have a, quote, plan document that has core provisions in it. That plan can also incorporate by reference other documents. And depending on what's written into your plan and what documents are referenced, there may have been an amendment requirement to add this provision. Similarly, there are disclosure requirements. There is some relief under recent guidance about required disclosure under ERISA, but with an important provision like this, there is a requirement to provide notice of it to employees. The second one, I think this is a big one, is that recent guidance by the IRS and DOL extended or essentially paused various deadlines in plan administration for participants. So for example, COBRA, which is being implicated a lot with furloughs, leaves of absence recently. It has deadlines for when someone can elect COBRA coverage and pay their COBRA premiums. Those are essentially paused for what they call the outbreak period, which is from March 1st through 60 days after the end of the national emergency. In terms of administration of that, there's a lot of interesting aspects. For example, one of the deadlines that is being paused has to do with claims deadlines and submission of claims and appeals. So because this guidance was essentially retroactive to March 1st, there could have been claims that were denied between March and May when this was issued that would have to be reprocessed. Third, HIPAA privacy and security. I think this is a big factor with COVID-19. Really two aspects to that. One is the use and disclosure of protected health information, which is essentially information obtained through the plan. So for example, if you have a self-funded plan and an employee is involved in administration, they see that somebody has been diagnosed with COVID-19, there are limits on how that information can be shared. The other aspect is with remote workers. So in the administration of a group health plan, you have to have certain safeguards to protect the unauthorized use and disclosure of protected health information. I think that presents unique challenges for remote workers. For example, people working with shared devices at home. Fourth, not directly related to COVID-19 guidance, but I think a big issue is COBRA requires various disclosures, one of which is a notice to people who experience a qualifying event. That's an event eligible for COBRA, such as a termination of employment. There are disclosure requirements related to that, and recently, over the past few years, there have been a flurry of lawsuits against large companies for alleging deficient COBRA notices, in many cases arguing that those deficiencies cause somebody not to elect COBRA. Several of those have settled for large amounts, I think some up as high as 6 and 7 figures. So I think it's important to review those disclosures, particularly as there's been a lot of reductions in force and furloughs. And similarly, as companies, I've worked with a lot of companies that have been furloughing employees. It's important to look at how your plan reads and how those rules are disclosed to employees. ERISA requires that a plan be administered in accordance with its written terms. So I've seen companies run into issues where they provide certain treatment for employees, furloughs, leaves, et cetera, and that it's not justified by the plan or that the person has not provided notice. Number 6, I think just another important kind of aspect, particularly related to furloughs and leaves. So a lot of companies who have furloughed people have allowed them to continue their benefits during the furlough. Now, if you have an insured plan, you probably need your insurance carrier's approval to provide this sort of special treatment. Otherwise, you risk being stuck with self-funding the benefit. I've seen this come up in lots of contexts. For example, in the mergers and acquisitions context, I've seen certain benefits promised to a buyer or seller's employees that it turns out the carrier won't honor. So I think that's another important consideration. 7, tax non-discrimination rules. These are something that are always coming up, but just a quick note, when you're dealing with special rules or providing special treatment during the pandemic, for example, allowing certain employees to continue their benefits on a furlough can raise tax non-discrimination issues. For example, if you only allowed front office people on a furlough to continue benefits, that might create a non-discrimination issue. Number 8, vendor contracts. Another aspect of benefits, I think, always important again, but with performance issues and other obstacles in the pandemic, I think it's important to be aware of what you've contracted with your vendors. For example, a lot of contracts have what are called force majeure clauses. I haven't seen these implicated, but they essentially excuse performance in certain extreme cases that are beyond a party's control. Again, fortunately, I haven't seen this come up, but it's something to be aware of. If you're relying on a vendor and something like that becomes invoked, it could create a lot of problems. Number 9, just a general, I think this is always a good point, but you got to be very careful with employee communications. One, to make sure you're adequately and properly disclosing treatment, particularly when it relates to when someone's coverage can continue and when it terminates, and also to be aware of various caveats. For example, there have been lawsuits about disclosures that were inadequate or that appear to promise something and didn't explain that the plan could be amended or terminated at any time. And then number 10, again, just I think a good general practice, which is the ability to demonstrate compliance is as important as compliance itself. You can take all the steps to ensure best practices, but if you don't have good documentation and record keeping and there's an audit or investigation, you may find yourself in a lot of trouble. So I think on that, we're about to start the Q&A here. Thank you.
That's right, Eric. Thank you for those. Just real quickly, Ann Tyler Hall sent me a quick chat, and I think that the idea, from our perspective, is always to be proactive. And Ann Tyler just wanted to put a quick comment in there, and then we'll kick off Q&A.
Yes, and it's been said so well by both Keely, Eric, and Kevy about the importance of being proactive and having a plan as we tackle these issues. And just making the point that similar to what Keely pointed out with employment issues, on the benefits side, we never see an employer that intentionally violates or runs afoul of benefits compliance issues, but then unwittingly they find themselves in 6, 7, and we've even had 8-figure penalty matters. In our last 2 years alone, we have helped clients avoid and abate more than $60 million in ERISA penalties. We don't want our clients to be in that situation, which is why it's so important to be proactive and to have counsel up front as you navigate these challenging, nuanced, novel issues.
Excellent. I think that's some really good gloss to what everybody has said so far. Let's jump right into Q&A, guys. The first question has to do with benefits and kind of what's emerging on the landscape currently as critical offerings. And I think, Josh, I'm going to pose this to you, and then we can have the rest of our team jump in as we find appropriate moving forward. We'll spend as much time as necessary to answer the questions well. But we do want you to recognize that this is not to be considered specific legal advice to you. Everyone's situation is different, and so we really want to understand the context of your specific situation before we do give you legal advice, or before someone from Gallagher offers you consulting services. So just please keep in mind that these are general questions to your Q&A. We are here to help, and we are here to have deeper conversations with you after this, should that be required. So Josh, the question is, what benefits are emerging as critical offerings to attract and retain employees due to the new climate?
Great question. And so I'll answer it in 2 parts. I mean, we're seeing a downturn in expenses on the medical and health plan side currently. So one of the things that we're seeing is how are employers able to either reinvest those funds or try to maintain the status quo, knowing that their business might be affected through these COVID times. So I think from the strictly benefit piece, there's 2 very important areas we're really seeing. Number 1 is telehealth. And I don't just mean Teladoc. I mean, I think that all of our pediatricians and all of our doctors have started doing that as a, sort of a reaction to COVID, the pandemic. But beyond that, what about the EAP services and being able to see counselors and speak to other areas besides just the medical benefit? So I think we're seeing a tremendous uptick in that. And secondly is voluntary benefits. There's a lot of people that can't afford to be hospitalized in this environment if they have lower hours, if they've been affected. So what about a hospital indemnity plan if they get sick so they can help afford their deductible? Those are the types of benefits that really speak to the employee need that we're seeing a tremendous uptick in this year. I'd say the second piece of this is really much bigger than benefits. I mean, I think there's a reality in the current world, and maybe even it's been happening for a handful of years, benefits aren't the sole reason people are coming to work for us anymore. So it is part of attracting and retaining talent. But I would say, and to some of the earlier points, what are we doing to help communicate effectively what our COVID policies and plans are? Are we being flexible with letting people work from home, in really trying to figure out how to care for their children through all of this? What are the policies and procedures if someone gets sick or there's an outbreak? So those types of maybe soft benefits are really the benefits that are outside of, traditional medical or ancillary plans are really important right now. And people want to know that they're being cared for and thought of. I think there's a reality that we do have to get back to work sometimes, but being able to effectively communicate your strategy and helping people understand what you as the employer is going to do if something does happen is really important to making people feel comfortable to go back to work.
And I'd love to just add to that, Josh, those are great points. We look at it from the benefits compliance side as holistic executive compensation, incentive compensation, retirement benefits, health and welfare benefits. You made some great points, Josh. I put down telehealth as one of the attractors. But we have worked with companies and even recently, because this pandemic has impacted different industries very differently. We have a company right now that's going gangbusters, and so they're looking to attract and retain millennials. I think it also depends on what demographic of workforce you're looking to attract and retain. But we've looked at incentive compensation awards and their corporate structure, tax implications. What are the administrative implications? And so I think this is just a great question, and I think there are multiple tiers of this: executive compensation, retirement plans. With the COVID-19 legislation, there was some flexibility now in distribution alternatives. Josh, you mentioned being flexible for employers, something to think about. And there are also now, and I think, Eric, you may have put this in one of your articles, student loan repayment through the end of the year, $5,250, a nice benefit, depending upon, I think a lot of it depends upon your demographic and who you're looking to attract and retain. And then on the health and welfare side, just consumer-driven plans, health reimbursement accounts, health savings accounts, giving employees some flexibility and some tax-advantaged vehicles. Eric, you may want to weigh in on this, but those were my thoughts. Is that it really needs to be a strategic, customized approach. We talk with plan sponsors a lot about what is your corporate structure, what are your primary objectives, and where are you right now? Where are you looking to attract and retain? So I think I think absolutely you're right, Josh. I just add a little bit of gloss from our end that we look at it from a few different angles.
Yeah, I'd agree with Ann, Tyler, and Josh on that. And actually, in my own notes, I thought of kind of, if I had to pick two things that I think are maybe more part of the new normal or have really been highlighted by the pandemic, I think it would also be telehealth. I mean, it doesn't seem like a vaccine isn't that close to the foreseeable future, and even I think going forward, that may be something companies consider for a long period, or if not indefinitely. And then voluntary benefits. Now, voluntary benefits have been picking up, I think, since the ACA was passed. But another, I think, a really key focus, and a lot of companies offer them already, but I think will be picked up even more as they look at, minimizing employees' out-of-pocket costs.
Great. Okay, good. This is fantastic. All right, let's move on quickly so we can get to as many questions as possible. This next question, Eric, I hate to put you on the spot. You've been talking for a little bit, but I think this is best addressed to an ERISA attorney. It's maybe more of a policy question, but you can add some gloss. I would like your take on whether state insurance departments should be able to regulate PBM pharmacy benefit managers, and any comment on the expected Supreme Court decision.
Thank you, David. Yeah, it's certainly a policy question. It's a good question, and I'll give a little background on this because I think it relates to a really important issue. So pharmacy benefit managers play a major role in the prescription drug supply chain for, among other things, employee benefit plans. They put together the formulary, they process claims, they negotiate rates between pharmacies and plans and drug carriers. So this case relates to the concept of ERISA preemption. As I mentioned earlier, ERISA preempts most state laws. The particular preemption clause here is for state laws that relate to employee benefit plans. So this case, which the Supreme Court is going to hear, is an appeal of an Eighth Circuit decision of an Arkansas PBM law regarding the reimbursement rate. So it's a kind of a transparency issue, and the law essentially required pharmacy benefit managers to reimburse certain drugs at or greater than the wholesale cost of the drug. It was intended to prevent what's called spread pricing, which is where the pharmacy benefit manager pays the pharmacy less than the wholesale cost of a drug, creates a spread, and in some cases the pharmacy benefit manager will pocket the spread. Sometimes they'll pass it along to the group health plan, but it's been a contentious issue. It's a very large source of pharmacy benefit managers' revenue. So in terms of what will happen with this case, your guess is as good as mine in terms of what the Supreme Court would rule. But the Eighth Circuit had ruled that ERISA did preempt this Arkansas law, and I think 38 or so other states have similar laws. So there certainly is a lot at stake. The issue from the pharmacy benefit manager standpoint is that they think that allowing this sort of state regulation would create a lot of market inefficiencies, requiring them to deal with laws in multiple states rather than a uniform system under ERISA. So whether that is something that should be allowed, my personal opinion is that with an industry of this size and with this much of a role in drug costs, it may be good for states to be able to have some regulation in that. Again, that's just my opinion, but again, a very important issue.
And David, maybe from the consulting side, I could just add in, from not specific to the law or the outcome, but from the PBM side, for our consulting practice, there's probably no more important area for our self-funded clients to focus on. Spread pricing, which Eric did mention, is a massive contributor to bottom line costs. And when we benchmark at 20 to 25% pharmacy costs for most of our clients, that spread can account to 10 to 15% of the money passing through those costs. So having someone truly understand where the money's flowing and evaluating that in your pharmacy plan, not only in the contractual language and the discount perspectives, but truly understanding exactly who's getting the money and how is very important to understanding your spend. So while we're waiting for those decisions to be made through the Supreme Court, I think having someone truly dig into your contract language is a tremendous way to find savings in a self-funded plan.
Okay, great. That was a good one, guys. Thank you. Let's move on to the next question. I have a more employment centric question, and this is probably going to land on Keely to start. And the question is, what do I do about my employees who are fearful of returning to the office due to COVID-19?
Yes, well, I've been hearing this question for a long time now, and it started all the way back when essential workers were called to work, and I put essential workers in quotes because I think you all are essential businesses. That's just the language that was being used by the state government and the federal government. We have employees across industries. So if you're thinking my employees are somehow averse to my workplace, that is just simply not the case. This is happening probably all across the country and certainly with the clients that I deal with. You're going to have employees who are fearful of returning who will fit in three general categories. The first category is employees who are fearful of returning who may have a protected leave right under the Families First Coronavirus Response Act. Big mouthful there, FFCRA. For those employees, I would put a big red sign up, just to stop and think about the possible protected rights those employees may have to leave, even though what they're saying may come across as just a general fear of returning. So I'll give you one example. So you have an employee who comes back from a hotspot. someplace that's considered a coronavirus hotspot, and sometimes that's different depending on which state you're in. That employee is fearful of returning because they're coming back from a hotspot. They're afraid of spreading COVID-19, and perhaps in your state, the governor has recommended that they quarantine. In that case, the employee probably has a protected right to leave for 2 weeks or 80 hours under the FFCRA. So that's big red sign. There are also cases where that employee might have a legally protected right to leave under other laws. It's not just FFCRA. Second category, I would put a big yellow sign next to this category, and these are your higher risk employees. Let's say you have an employee who has had known to have diabetes, asthma, some type of complicating condition. Perhaps they're an older worker. Now, not to be confused, earlier I said you can't prohibit older workers from coming into the workplace. However, you may have some older workers approach you and ask if they can work from home because of their higher risk. So this category, I would say, I would put this category in yellow, the second category. If you have an employee who they don't necessarily have a legally protected right to leave, but they could be in a higher risk category, I would encourage you to stop and think here about other areas of legal risk, such as legal risk under OSHA, legal risk under your under your state workers' compensation law. I just came from Pennsylvania. Or potential legal risk in other areas. So I would put that second bucket in yellow. And then finally, there's the third bucket, and these are the employees who maybe, they just been watching a lot of news and they are fearful in general about returning to work for one reason or another. For this third category of employees, if they're failing or refusing to report to work, you generally can follow your typical policies for non-compliance or failure to report. However, as Kevy indicated earlier, we have to operate in general under the standard of an upended type of legal risk where all employees who are fearful of returning should be evaluated on a case-by-case basis to make sure there isn't some type of legal risk management reason why the employee should not be granted leave time. So excellent question. I get that pretty often.
David, sorry, I would love to chime in as well and just reinforce what Keely said, but again, going back in that HR framework, just the importance to proactively share with your teams, even before they come to work, if you are kind of going through that phased reentry process, reiterate what you have done, what measures you have put in place to ensure their safety as best as you can, whether it be, the reconfiguring of workstations, temperature taking, modification of schedules. We're going to come in teams, team A and team B, and here's the schedule. Our cleaning processes, every night are going to be heightened, or, the sanitation that they're going to be using is, kind of at the CDC recommended levels or whatever that is. Be proactive in conveying all the things that you have done and thought about, and that you have put them, kind of at the forefront of your mind as you have really, put your plan in place. That will help at least allay some of their concerns. And, I think help everybody in the long run know, what to expect.
Excellent. We had a question come in that I'm going to kind of push up the queue a bit here, because I think it is one that we've heard here at Hall Benefits Law from a number of clients, and it has to do with mid-year elections. And so, Eric, I'm going to ask that you kick this answer off for us. The question is, does the CARES Act allow for mid-year elections? For example, the employee was furloughed the same day he was eligible to enroll. He returned to work and now wants to enroll 3 months after eligibility date. Help us out, Eric.
So it's a great question. I think the answer is yes. I think there could be a mid-year election here. It's not part of a CARES Act rule, but I think certainly nonetheless allowed. So just one thing to distinguish is there's a difference between being able to enroll or change an actual plan option and then being able to change a cafeteria plan quote election, which is basically just a choice to pay pre-tax for something. So as a general rule, cafeteria plans, they're limited on when they can allow people to change their pre-tax elections mid-year. Outside the cafeteria plan rules, you can certainly allow someone to enroll mid-year. The one caveat being that you may need approval from the insurance carrier, or if you have a self-funded plan, from the stop-loss carrier. This particular scenario, I think, under the general cafeteria plan rules would be allowed. The person had what's probably considered a change in employment status that affected eligibility for benefits. Those are really the two components for being able to make that particular election change. So the person would have been eligible for benefits. They went on a furlough, lost eligibility. They returned from a furlough. That's a change in employment status. And they returned to a status that would be benefits eligible. That person would be generally allowed to make a mid-year pre-tax election change to enroll. Now, in a broader sense, there actually is also relief from the IRS about cafeteria plan elections. And among other things, regardless of whether there's a change in status, for 2020, the IRS has issued guidance that certain mid-year pre-tax election changes can be broadly permitted. One of those is to allow someone who previously declined coverage in 2020, such as during open enrollment, to make a mid-year election to get in the plan. If you want to allow that type of a change, you'd need to amend your cafeteria plan. You don't have to do it up front. You have to do it by the end of next year, and you have to disclose that opportunity to employees.
Great. Go ahead, Ann Tyler. Then I have a segue question.
I would just add to that, we've got a lot of great materials and resources. We've been busy at Hall Benefits Law writing about all these changes that are coming out. Eric, you'd probably agree with this. Weekly, we're getting new guidance as it pertains to health and welfare benefits, and certainly if you add in retirement plans, but just benefits related legislation and changes, notices from the IRS. We've got some handouts that enumerate some, that provide some of the articles that we've written. We're also going to be submitting an article in the next week that highlights some of the primary changes and legislative changes to benefits, specifically health and welfare benefits, that should be coming out in the next week. So you can reach out to us if you'd like a copy of that article. But we write regularly on these changes and the guidance, and it is important. It's a great question because these changes are happening fast, and you as an employer need to be out in front of that. And we want to be a resource and counsel to help you with that. So please sign up for our newsletter or just check out our blogs. We're constantly and consistently writing about recent legislative changes, IRS guidance, DOL guidance, and it's been a busy season.
Okay, guys.
Yeah, certainly a lot of guidance.
In the vein of enrollment, guys, I have a question here from the audience. Thinking ahead, let's get practical. Are you aware of any resources to establish a remote or online benefits fair for open enrollments? And Kevy, you're grinning, so I'm gonna let you kick this one off.
Actually, I might kick it to Josh.
Okay.
Who might be best served, and then I can chime in.
Perfect.
So we're in the front end of this, obviously, in the online benefits fair space. We certainly have the resources. The vendors we use in the benefit fair arena are very open to this because we are all trying to get creative how to deliver value to our customer base. So absolutely, we have done some. It is a different feel and vibe. It's got to be the right population. It's very hard to get people. You know, it's one thing when you're on site where you get people to walk through a common area. It's a little bit different to get people to dial in. But yes, we're doing them. It's kind of yet to be determined exactly how effective we find them to be. But all of the vendors, for the most part, are excited to do anything they can to be customer facing, as are we. So anything we can do and they can do, we've tried to create. And that is one area we have had some success. No biometric screenings. You know, we've amended some vendor participation to possibly sending people on site for biometric screenings or doing things like that through primary care physicians. But so it is a different feel, but it certainly can be effective still.
Josh, real quick, how can people reach you if they have further questions about that? What's your email address?
Yeah. Yes, it's Josh_Anderson and the number 1 at ajg.com, and would be happy to answer any further questions on any of these topics outside of legal advice.
Okay, I'm going to move to another hot topic, pun intended. Keely, talk a little bit about what to do with employees who've requested to go on vacation in a hotspot, or just the whole idea of these hotspots geographically, and what the employer approach should be.
Yes, well, that's another excellent question. It can be kind of a complicated one because there's some business strategy and HR strategy involved here. Employers, you really have a couple of options. But before I talk to you about your options, just so that you're aware, there are a few states, and you may be in one, I think there's just a handful, that actually prohibit employers from terminating or taking disciplinary action on the basis of something that an employee did outside of work. So if you may want to check your state law just to make sure that you're not in one of those states. There aren't many, but that's just a little caveat up front. So for the most part, unless you're in one of the states that would prohibit you from doing so, employers, you do not have to grant every request an employee makes for vacation time. Employees may have the burden at your workplace of requesting vacation time a certain amount of days ahead of time, and then telling you perhaps under the circumstances the request may include a check the box as to whether or not they're going to a hotspot, or it may include a request that the employee provide you with some information as to where they're going, because when they return, you may then be required to give them another 2 weeks of leave under the FFCRA, Families First Coronavirus Response Act, in order to quarantine. So I'm not advocating for you denying vacation time. That's more of an HR issue, but I get the question a lot of whether employers seem to think that they are required to grant every request for vacation time. You certainly are not, unless there's a union contract or some type of state law, as I just mentioned, that requires otherwise, or if you have an employee with a contract or something like that. But your general employee request for vacation, you are free to ask the employee where they will be going in making the request. And as always, employers, make sure you're applying the same standard across the board. Alternatively, if you do not want to get into the perhaps temporary practice of denying certain vacation leave requests, employers, just be aware that when you're approving vacation requests, you may also need to approve or at least tolerate an extra 2 weeks of leave when the employee returns from a hotspot to comply with the quarantine requirements. There are some states where the governor has recommended quarantine, and in that case, the employee isn't necessarily required to quarantine unless a physician would order them to do so. There are some states and areas, however, though, where employees are actually required, individuals are required to quarantine when they come home from hotspots. So first, know your state law as to what the requirements are for when employees return from hotspots. Number two, think about what you can tolerate. Imagine that a whole group of your employees is asking to vacation in a hotspot. Can you tolerate that? The reason why that's important is because these policies have to apply to everybody. And then thirdly, just make sure whatever decision you make, it's applied consistently to all similarly situated employees.
Okay, great. I just made a comment to the panelists and organizers that nobody's dropping off and it's after 11 o'clock. So I think that's a good sign. Let's do this, everybody. We've got more questions. Panelists, can you give us another couple of minutes just to wrap up maybe one last question? I'm going to pick the one I think is most applicable across the board, that might bring the most benefit to the most people. Eric, can you talk a little bit about tax-favored benefit strategies in light of COVID-19? So employers who are looking for ways to leverage the, I wanted to say take advantage, that has a negative connotation, that want to leverage some of the abilities that have been given to employers here. And we'll try to wrap up in 5 minutes or less.
Sure, and I think Gallagher can also weigh in on this one as well.
Absolutely.
I think the first one I'll point out is the CARES Act allowed for 2020 employers to pay up to $5,250 of employees qualifying student loans tax-free. That's brand new. In the past, something like that hasn't been allowed, with a very rare exception under certain 401k plan arrangements. So I think that's certainly one. I myself still have student loans. I think a lot of employees have student loans. So as a form of compensation for competitive purposes, that may be very appealing to employers. I think other items, one thing I've talked about in the past related to COVID-19 relates to fringe benefits. We still have a lot of people working remotely. I've gotten questions about whether employers can pay for things related to home office setup tax-free, phone lines, etc. I think in some cases that can be possible. There are rules for what are called working condition fringe benefits, which essentially allows an employer to pay for something tax-free if the employee would have been able to take a deduction if they had paid it themselves. So I think that's another aspect of it. Also, as a general matter, employers generally provide health insurance benefits like health insurance, medical, dental, vision, employee assistance programs. Those are all tax advantage vehicles. So I think those are some various aspects.
What about from the Gallagher perspective?
Yeah, I think Eric did a good job of touching on it. The one vehicle that we're seeing pop up right now that we haven't seen really since 2008 that we've started helping some employers, and it's a little outside of the traditional benefit plan, is supplemental unemployment benefit plans. So we are seeing those pop up, and that's really for populations that are looking to do or being forced to do layoffs and helping make those employees whole through some tax preferred vehicles. So there's a lot of consulting in that, both on the tax side, on the legal side, but can be a tremendous savings financially because the employer match taxes are generally, as if it's set up properly, are something the employer or employee would not have to pay. So it does go along state mandated unemployment benefits, but it's a great way to make people whole and employers to save a substantial amount of money in doing what's best for employees if you are forced in a layoff situation.
Okay, well, with respect to the time that we set aside and respect to the time that our plan sponsors and other folks have joined us, time restraints they may have, we're going to wrap up. But I just want to personally thank each and every panelist, first of all, and each and every attendee. You will be receiving a copy of today's presentation. Please don't forget to directly download the resources that we have given you. There's true value in these, and I would suggest that if you're an employer, you do download these and read through them. And if you do have questions, there's contact information there. Please don't hesitate to reach out to our team or to the team at Gallagher. Gallagher, thank you so much for the partnership. We appreciate you guys immensely, and your proactive approach and the way that you work with employers is really a model for the industry, and we appreciate the way that you do business. Hope everybody has a wonderful day. What a great way to start the day. If you do have questions, again, you can submit those to clong@hallbenefitslaw.com, or you can reach out directly to Kevy or to Josh. Josh shared his email address earlier. My email address is dhall@hallbenefitslaw.com. You're always welcome to reach out to me directly. Thank you again. We look forward to doing this again in the future. Have a great day.